Great. Okay. Welcome to those who are both here with us, which, if the registrations are correct, mediators, and of course appear for parties in mediations. And through that, we've learned some things about what makes for a successful mediation. Now, I'll speak in a moment about what success actually means in a mediation context, but we haven't presented this topic before, but we've decided that rather than the sort of traditional, one person speaks and then the other person speaks, we're going to just sort of do an Abbott and Costello approach where we're both speaking and interrupting each other during the course of it. So I'm going to throw over to Richard to join me now, and we'll, between us, sort of pick up this camera. I'll stay on this side, Richard, you can go on that side. So we mediate in two different areas. So just for myself, I'm a employment industrial law specialist, and so when I'm called upon as a mediator, it's sometimes in the context of pre-litigation, so that a letter has been sent on behalf of an applicant, but they haven't commenced proceedings. That's relatively common in discrimination cases, but it's also arisen in other contexts as well, where there is perhaps a separation between an employee and employer that's occurring, but they don't want to have to go to court, but they do want to try and resolve it. But I've also been mediating in circumstances where there is litigation on foot, including complex class actions involving employment, industrial claims, and the like. And in those cases, you have pleadings and you have some capacity to identify legal issues from that. So that's my background, but Richard, he can introduce himself. He does quite different types of mediations, and more commonly, I think, than me.
Yes, as Ingmar said, my name is Richard Sergi. I practice mostly in the area of medical negligence, and as Ingmar's indicated, we're both accredited mediators, and just by way of background, the mediation accreditation system is essentially run through the Resolution Institute these days, which is the successor to some former organisations, IAMA, the Institute of Arbitrators and Mediators, and LEADER, Association of Dispute Resolvers. So accredited mediation requires you to engage in a week-long effort of intellectual rigour that leads you to calling yourself an accredited mediator, and of course you have to maintain those skills to maintain your registration throughout the year. As Ingmar says, there's different types of mediation work. Post the commencement of litigation, which is what I'm involved in mostly, being involved in medical negligence, that is after someone commences proceedings, and then getting towards trial usually as a way of preventing it, and of course the pre-litigation scenario that Ingmar's outlined. Now, I thought it might be useful by way of background just to remind ourselves of why we're engaged in mediation. When I first came to the bar, it was essentially unheard of. Nothing went to mediation, and the courts realised they couldn't cope with the amount of litigation that was happening. So various practice notes have come into play. Practice note SCCL7, the Supreme Court Common Law Division, deals with professional negligence list, and that includes medical negligence and other professional negligence too, of course. And essentially what that practice note includes is a few different things to do with mediation, but in the end, the clause 23 of that practice note is to the following effect: proceedings may be referred to mediation by the court with or without the consent of the parties if it considers the circumstances appropriate. And that's how we find ourselves mediating most of the time, because the court, unless you come up with some reason why it shouldn't go to mediation, it will go to mediation, so the court can try to get rid of as many matters as possible. There's a practice note 6 of the Supreme Court I thought I'd mention, which deals more with mediations where the court appoints the mediator, but there are some one or two provisions in there that are consistent with Common Law Practice Note 7, and then the District Court has an equivalent provision in it, so that if anyone says, why are we here, what are we doing, etc., you can point them to this. The purpose of this, of course, is, as I've indicated there and as I've mentioned before, to avoid going to trial. The court wants to avoid things going to trial because it doesn't have the resources to deal with everything that's before it, and more importantly, the parties generally, if they can, want to avoid trial as well. In the area in which I practice, and certainly the area in which Ingmar practices, you're dealing with individual litigants, often people, real people, who are quite anxious, nervous. Some of them might come into your room and say, whether they're a defendant or a plaintiff, and say, whatever happens, I don't want to go to court. So that's your starting position when you're acting for them. But it's a way, in general terms, of avoiding a trial. And so it's important, as Ingmar outlined at the start, to make sure that you prepare yourself for that outcome, that is, avoiding trial.
So in the pre-litigation sense, it's a useful avenue to reach a resolution that doesn't involve just sending a series of solicitors' letters to each other. And it's not a bad idea to raise with the client at a certain stage. Sometimes, particularly in employment context, things can go downhill quickly if there's just a series of angry letters being sent. And to get people in a room with a trained mediator, I mean, there are obviously costs involved. You're not going to do it over a minor matter of minor value. But if you're dealing with a matter which has either serious ramifications for the reputation of one or both of the parties, and in discrimination and sexual harassment cases, that looms large, and or you're dealing with very significant amounts of money, which is often the case if you're dealing with senior executives and the like, it makes sense to avoid litigation and move into mediation at an early stage.
All right, so here the heading is positions and interests, and often people treat them in the same way, but they're actually different ideas. A position is really, what you want. Often a party will say, well, I want, $10 million. The other party will say, well, I want a verdict for the defendant. Now, they're diametrically opposed ideas. They're diametrically opposed positions. But in coming to the position that you want, you have to consider your own interests. They might not be the same as your position. So, for example, if you're a litigant in person, you might have particular concerns about costs. You might have particular concerns about delay. If you're a corporate party, you're probably less concerned about those things. But as Ingmar said, there's some particular interests that you have to bear in mind. Personal, family circumstances, cultural, other forms of embarrassment, where you want to avoid litigation. I remember one time I was acting for a doctor. Her background was Korean. She was very, very embarrassed about the situation she found herself in, being a litigant in proceedings. I was for her. She was the defendant. I thought she was excellent, and I thought she had excellent prospects of defending the matter. But she was so embarrassed about her situation, she hadn't mentioned it to anyone in her family, her parents, her siblings, anyone, and she was carrying this enormous weight around. So although her position was a verdict for the defendant, she had another very important interest to take into account, and that was her own well-being, really, and her own embarrassment, professional reputation and things like that, as Ingmar was talking about. Some plaintiffs, as indicated before, will come in and they'll say, look, I was terribly badly done by. I need lots and lots of money, but I don't want to go to court. Now, those two ideas are hard to reconcile. Their position is they should win and get lots of money, but their interests are they don't want to go to court. So it's important when you're running through the mediation and preparing for the mediation to realise that you can't be too bullish about adopting a particular position. You can, at least ostensibly, but have in the back of your mind, look, what are the interests I've also got to look after? Sometimes you have to save yourself from your client too.
All right. What does being successful at mediation mean? And this influences the approach you take as the advocate in the mediation. And being successful at mediation, if you think about it from your client's point of view, is not getting 100% of your best case or even getting 75% of your best case. Being successful at mediation is reaching an agreement that your client is happy with. Not as happy as they could be, but happy. When I commenced practice, which was so long ago, I'm not going to name the year, but it was about that time the Law Society did a survey. And I often mention this to clients as part of preparing matters for mediation. And it surveyed clients who had won after a contested hearing in court, lost after a contested hearing in court, and settled at mediation as to their degree of satisfaction and happiness with the overall result. And unsurprisingly, those who lost were least happy, but perhaps surprisingly, the happiest were those who had settled at mediation. They were significantly happier than the people who had run and won in court. Because, as I say to clients, running a court case is not a happy experience. And it's rare that you get 100% of what you think you deserve in a contested hearing, and there's often adverse outcomes. So you might succeed, but you succeed in circumstances where you're not believed on certain things. And also, and this is critical to happiness generally, as someone who's an employment lawyer, it's about having control. When you hand it over to the judge, you lose control over the outcome. It's in their hands. Whereas in a mediation, it's in your hands, and you then, as a result, are more likely to be happy with the outcome. All right, next topic. Over to you, back to you, Richard.
All right.
Preparation.
We're probably not as funny as Abbott and Costello, but we'll press on anyway. As Ingmar has said, it's prior preparation is fundamental to achieving success. It's easy to say, it's perhaps trite to say, but it really is true. Position papers are essential. I know in my area, because there's there seems to be a never-ending sausage factory of cases that we deal with, that people sort of tend to get a bit blasé and ho-hum about the position paper, but I think it's a bit of a mistake to underrate their utility. It's really important to be clear and engaged, and if you can get the position paper, I know as a mediator I'm harassing people to get position papers to each other at least a few days before the mediation so that they can have a proper understanding of where the other side's coming from. Often you'll get a good understanding anyway because you've been at odds with each other over months and months and months, sometimes speaking civilly to each other, sometimes not. But it really is important, I think, in the position paper to be clear. That doesn't have to be long. You don't have to sort of argue the case or go through all the evidence, but you do really need to be clear about what it is you say are the important points and engage with the other side about what they say is their defence or what they say their case is. And it's important to prepare yourself in that respect by really understanding. I mean, it sounds a bit, as I say, trite, but often people come along and they're not really across what they've got. That's not always the case, but sometimes it happens, and it can really, really upset the apple cart in trying to get a resolution to the matter if both parties aren't there and prepared yourself. And you don't want to turn up if the other side knows more about your case than you do. That's when you can get into problems dealing with your client and perhaps ending up with an outcome you don't want, or worse still, going to trial in those circumstances.
Managing expectations, though, I think is probably the most important thing that makes a difference between the likelihood of a mediation being successful or not successful. If one party walks into the room thinking the worst they could possibly do is pay $50,000, and the other person walks in and thinking the worst they could possibly do is receive $1 million, then it's almost going to be impossible for that matter to settle. And that tends to happen because one side or other, or both, have not managed their client's expectations going in. They've allowed the client to come up with their own view and have just gone, sure, we'll go. If that $1 million is what you want, we'll get $1 million. And if that's the approach you want to take it to court because it's not going to settle at mediation if you know, having thought about it, that a more likely settlement range is between $50,000 and $150,000. Unless you make the client understand that, you can also say to the client, this is your matter. You don't have to settle for $1 less than you want. But to make them understand and set their expectations, it's much more likely that at some point in the mediation, they will start to come to a point where you're likely to meet middle ground. So managing expectations is really important. And that requires you, as the person running the mediation for your party, to have given careful thought to that issue of seeing it from the other side, and where they're coming from. Now, you can't deal with their unrealistic expectations. That's out of your control, and we'll come in a minute to some of a checklist of things that you should be doing, and one of the checklist is, preparing your client for the other side to be unreasonable. But you can at least prepare your own client and get them in the right mindset for success. The other last dot point on that slide is preparing the other side. Now that sounds a bit odd, but by that I mean making clear to the other side. The position paper should do this, but sometimes in some contexts it's useful to pick up the phone. If you have, it's not just a money case, but there are certain things which are lines in the sand, it's useful to communicate that in advance. So that the other side can, if they wish to, adjust their bargaining position to have regard to what that issue is. So particularly if it's not a monetary issue. So confidentiality is fundamental to your side. That if that isn't going to be part of it, then we're not talking. In circumstances where one side may wish to publicise the outcome. So that type of thing. And the other thing that's just useful to talk to the other side about is just get some of the basic facts right, which might be relevant to the outcome. So if, in an employment context, you just want to be clear how much the person was being paid, when did they finish, what were they paid out on termination. I mean, it sounds pretty basic, but it's amazing how a mediation can go off the rails because people are actually starting with different figures in the first place. So that type of communication, i.e. preparing the other side, is also really useful. So you walk in with a common idea of what are the important things. And to give an example, last week I had a matter where there was miscommunication between the parties in advance. So it was a private mediation. It hadn't been ordered by the court. And there'd been a communication from one side to the other to the effect of, look, if we can put a proposal as to this subject matter that's suitable, then is that going to be a basis that we can resolve the matter? And the answer came back, yes. So when they got into a room and the one side said, here's 7 things we want, the other side was hearing, because of the prior communication, there's really only one that was really important. So they spent 2 hours preparing a position on that and said, and as we're not offering anything else, the other side I had to hold on to them to stop them walking out at that point because there'd been a miscommunication. So it's not a bad idea to have a communication beforehand, but when you are having that communication, do be clear. Don't send a mixed message, because there's nothing worse in a mediation than people thinking that you've not been straight with them. That's more likely to cruel the mediation than being straight with them and asking for an amount much more than they're prepared to pay, because at least you've been straight from the beginning.
I'll just before you move on, I'll just go back to prepare yourself, because there's a couple of things I wanted to mention. One of those things is a pre-mediation advice. Now, in the area I practice in, I know that a lot of solicitors, it's the bane of their life to provide their clients with a pre-mediation advice, but it's very important for a plaintiff or another party to provide that pre-mediation advice, because as Ingmar says, you need to prepare your client. You should work out what your position is and what is in your interest. Again, going back to the point of view of a corporate defendant, it may well be that in the health context, your client really doesn't want there to be any litigation about a certain issue, whether it's the availability of termination of pregnancy or something that's going to be on the front page of the Telegraph. You've got to say to them, look, you've got a good case on liability, but you have to factor in something else. So that's an important aspect also. And as Ingmar says, you've got to be prepared for, or tell your client and remind yourself of what if the other side behaves unreasonably? What if they take a ridiculous view? How are we going to prosecute the mediation? Are we just going to maintain our course, go through it? What are we going to do? Are we going to walk out in high dudgeon after the first half hour? Probably the former is better than the latter. You should know your costs and your disbursements and what your client might have to pay back, whether they have any obligations to Centrelink, NDIS and all that sort of thing. And sometimes particular litigants might have particular terms in mind. I know in Ingmar's area, often they relate to terms of employment, engagement, re-engagement, all the rest of it. Sometimes for the medical negligence context, if they involve individual doctors, you might want deeds of release rather than consent judgments and all that sort of stuff. So these are all the things you should be alive to before you even get there.
So just on that last dot point, detailed terms. So in some cases, it's just a money thing. There's nothing detailed about it. In other cases, there are aspects which are quite complex, or the claim might involve, amongst other things, a request for an apology, or it might involve some statement, public statement that's going to be made between the parties, and there might be a series of other terms, and a mediation is much more likely to be successful for your client if you have drafted them all before you turn up. And I've been in a number of mediations where around 4 p.m, the money's settled, and then the parties turn to terms, and I find that no one's actually thought about it, but then they start thinking about it and they start writing them down, and we're still there literally at 11 p.m. Whereas if people had come with their document, to the extent to which an apology is being proposed, and they, employment context, it's amazing how long, having already agreed that it's 780,000, that the parties will prepare to spend in a mediation debating the text of the apology. But if there's a preparedness to provide one, and it's been flagged in the position paper, think about it in advance, write it down so you come. I mean, you still can negotiate it, but obviously it saves a lot of time if you say, here, here's a draft, and work from that. And indeed, depending on the tactics and the mediator, you might even start preparing some of the deed, providing a draft of your terms at the same time as you're still talking money, so that whilst your side is thinking about the money and what the next offer is, and you're debating it in your room, they can be sitting looking at something and doing some work to speed things along. And I have to say, I mediated a class action which I thought was going to be very complex, and it turned out, through a combination of the parties having had some discussions in advance and there being the party with the money turning up with terms, we'd wrapped it up in 4 hours. And I thought that was fantastic, but it was all about the preparation of those parties.
Okay. The authority to settle. Often you'll hear a mediator say, I hope there's someone here with authority to settle for all the parties, etc., etc. And generally we sort of, of course there is, An example today, I was mediating a matter. One of the parties, because of their corporate structure, every time we had to do something, required innumerable phone calls. I mean, it was maddening for everyone, and it's very hard because there was more than one defendant to keep everything flowing. It's hard to keep a plaintiff in it. It's the only time they're going to mediate. And that's one thing I'd impress on all of you here. We all get a bit bored with mediations and sort of say, come on, let's go. Usually for most litigants, it's the only time they're ever going to do it. And we just have to always remind ourselves, be patient. And that's what I was trying to do today with this defendant who should have known better. But it's just so important to keep everything going along smoothly, that if the person with authority to settle is not there, that you have a very good, clear, prompt line of communication with them. Otherwise, it makes it very difficult to maintain momentum, and it can also poison the well of goodwill that there is when people turn up. If you're saying, look, I'm very sorry, I've got to go off and ring Blogs who's not here, or whatever the case is. So that's really important, even though it's, again, one of these obvious matters. Support person, obviously, it may be in your case as well, but certainly in my case, you often have support people if people have psychiatric injuries or other similar personal injury, that a support person will come along. The reason why I mention that is because it's important in terms of confidentiality, and sometimes that support person, if things are being done remotely, is not actually with you, which is something to be alive to in terms of signing them up to the terms of confidentiality. The last stop point is something that those of you who act for defendants in the health area are very conscious of from time to time. Rarely. Defendants are in the situation where an acknowledgement of what's happened to the plaintiff is very important to make, sometimes an apology, because that can do everything to improve the prospects of a successful outcome. And it's important to get that person, even if they just sit there like a pudding, to acknowledge the importance of the matter to the litigant. And again, that's part of preparing for the mediation, finding out who's attending. And you will know from your cases those situations that require someone from the defendant to be there, an appropriate person. Sometimes they might say something themselves, sometimes you might say it on their behalf and just refer to them. But that's important.
Yeah, I just want to re-emphasise that if you're acting for a respondent, it's not uncommon, I find, for some of the more significant mediations I do, for the respondent to consider the proceeding to be of the proceeding which is being mediated of potential critical importance to the organisation, not just a minor thing, but critical importance to the organisation. And yet, a view's taken that, you know, a relatively low-level manager with some authority is all that needs to be sent to the mediation. And you can say to your client in that situation, it is, if you actually want to give this mediation the chance of success, and clearly you place a high importance on it, please send someone who is the most senior person available to come along. Yes, they will spend half a day in a room chatting to me about, you know, the latest sporting event while they're waiting for the other side, but there are many mediations that fail because that person's not in the room, they don't know what's been going on, they get a phone call, and the person who's relatively low says, look, you know, I know you told me I couldn't go over $500,000, but you know, will you give me authority to go up to the next level? And they're not sitting in the room, they go, no, put the phone down. And the matter continues in circumstances where the difference between that figure and the figure it could have settled on is half the costs that will be spent plus the potential reputational damage. But they're not in the room, they're not there. And also, as Richard said, when it comes to individual employees, it does really help for them to think that the senior person is listening to them and is acknowledging them. And in some cases, perhaps it would actually be useful for that manager to learn from the experience more generally. But I'll put that to that's not the mediation, that's a more general observation.
I'll just add two more things. Sometimes that's all the litigant wants, is just to be acknowledged, almost more than any compensation. They just want to be acknowledged and want someone to say, I'm sorry. The other point I'll make is that if the senior person is so important they can't spend the whole day there, we'll just say to them, look, come for the opening.
Good point.
Show your face.
Yeah.
Say something if you can.
Yep.
But be there, and then you can go off and do something that you regard as far more important.
Yeah. No, I've had that method work on a couple of occasions very successfully. Conduct.
Okay, this is all pretty obvious stuff, but it's worth repeating, often because people turn up after arguing with each other for months and months, and they just go, you know, so-and-so, I don't think much of them, blah, blah, blah. Mostly, it's not something that's a problem. Playing the ball, not the person. And in terms of openings and things, if you are instructing someone or if you are appearing yourself, try to avoid the sort of aggressive opening as to why you're going to win and why the other side's hopeless. In the end, the object of the exercise, we have to keep reminding ourselves, is to reach mutual agreement. We can think about the interaction at trial. It's very robust. In some way, it's aggressive. It can be quite upsetting. We want to avoid that. In terms of negotiating at mediation, be consistent if you can. One thing that drives parties to distraction sometimes and confuses them and poisons the well, as I say, is if the increments in offers, go up or go down by 15 and then 20 and then 150 and 250. Have a clear process in your mind about how you're going to do it. And be clear in what you're saying. If it's plus costs, inclusive of costs, whatever the case is, if it's at the start, say anything you want. And at the bottom I put, don't surprise people. say at the start, these are going to be, by a deed of release. Make it clear if there's something that's a bit out of the ordinary in the area in your practice, make sure you tell the people that you're opposed to that's what you're going to be after. And being patient is something that I like to stress all the time because it is so important. And because we do it all the time, we do become impatient, but we have to remember that the litigants, it's frustrating for them and it's unusual, it's foreign. Be respectful and culturally aware. Sometimes, as a man, you have to be conscious, if you're dealing with Muslim litigants, often, you don't go and shake the woman's hand, there's other ways of greeting them, all that sort of stuff. Be cognizant of personality, personal circumstances, sophistication of the other party. A lot of mediation is psychology. Stand in the shoes of the other person. Be them. If they're a person who is, poorly educated, or if they don't speak English, or if they're elderly, or whatever the circumstances are, you have to try and be them. Otherwise, you're just going to fumble around and you're going to upset them somehow or other, and that doesn't help the objective of successful resolution. Be encouraging and engage, and by that I mean with appropriate offers. Sometimes parties want to send a message to their opponent and say, look, this case is worth $1 million, every day of the week, I'm not going to take anything less, and there's no compromise. They sort of go from $1 million to, 950 or 975. That's fine, but you've got to realise you've got to encourage the other side. You have to encourage them. You don't want to sell yourself down the river, but just be mindful of the fact, as again, standing in someone else's shoes, stand in their shoes and say, how are they going to respond to this? And providing the information to sort that out. That's obvious. Sometimes a defendant might say, well, what are your costs and disbursements? Oh, I'll get back to you, and provide it. If you want to settle it, just provide the information. But as Ingmar said about a few things, these things appear obvious, but it's worth just reminding ourselves of them so that we can get the outcome we want, which is to avoid going to trial.
So, because we both do this also as acting for parties, can I just re-emphasise one of the things Richard said, that is, for those who are taking a speaking role in a mediation, it's quite different to opening a case in a court. Occasionally people forget that, much to the amusement of the other lawyers in the room. So when you open at the beginning, yes, you would say a few things that would be relevant to your client's position, why your claim is worth X, why their claim isn't. Just perhaps to be clear, that everyone's clear why you're there, but your focus in that opening statement is interests, the common interests. And that takes me, if I can just go back a couple of slides, one thing we didn't maybe spend enough on is cost disbursements to date and to the end of trial. Often in my cases, I'm dealing with a jurisdiction where each party are likely to pay their own costs, but even in circumstances where it is a cost jurisdiction, but the applicant is unlikely, if the respondent wins, is unlikely to be in a position to actually pay those costs, it's actually useful to identify what those costs are going to be going forward, because it's useful at a certain point for both parties to say, okay, this is how far we are apart, but the difference is actually how much it's going to cost to run the matter. So shouldn't we be, it's the old line, rather than spend money on the lawyers, why don't we actually use that money to resolve it today? And that's that idea of common interest. Like the parties at a mediation have a common interest to avoid litigation. They might also have a number of other common interests which can be emphasised in your opening statement, and it might be confidentiality, reputational risk. It might be that there are things that can be offered other than money which one party or other would have an interest in. They're the things you lead with. That is, say something about position, but focus on how the matter can resolve and why it should resolve. So because that's what you're there to do, remember. You're not convincing the mediator. It doesn't matter whether the mediator thinks you've got the winning side or not. All right, sorry, I jumped ahead. We're going to ethics.
Here we go. Very briefly, I mean, you all look very ethical and straight up. So one thing, I'll just touch on this very briefly, because there have been cases and decisions about it, I'm sure you know. But never lose sight of the obligation to be honest and frank. You have a duty to the court and the opponent. There are solicitors' rules and barristers' rules that deal with this. Sometimes don't try to be too cute. It's one of the benefits of the confidentiality agreement, and that people can be open and frank about what their case is. That means you have, some slightly wider license than you would have otherwise to reveal perhaps some weaknesses in your client's situation. But one thing people, and look, it rarely happens, and perhaps it happens less now than it used to a long time ago, you can't be loose with the truth. You've got to be frank about what's going on, whether it's, whatever it is. I won't come up with examples because I might betray something.
So that's the one basis upon which a settlement can be set aside ultimately if it's been entered into on the basis of some
fraud
or a serious misstatement of fact.
And the other thing is, if that does happen, you're not actually helping in the resolution of the matter, because if you're discovered, that's it. It's all over. Yeah. Probably for them in all time. Confidentiality.
Yeah. Well, look. I mean, I know you know this, and it's in the mediation agreement. But sometimes I find applicants in person still have difficulty with the notion of confidentiality, and I've had cases where the thing starts going awry when someone walks into the room and says, the manager's just been told by one of the people there that we've just offered X in this supposedly confidential room. And so it is a matter of just reiterating to the client that if they want to settle the matter, they've got to make sure that they stick to the confidentiality regime, because it's likely to be an important aspect not only of the mediation itself, but of it sticking. So they need to accept that that's part and parcel of the process, that they maintain confidentiality. And you were going to say something about social media.
Well, I was very briefly, because someone did raise it the other day with me about plaintiffs getting on social media and revealing this, that or something else. And perhaps the obligation really falls on those of you who are representing individuals rather than corporate clients who are used to mediation and the notion of confidentiality. But it obviously applies well after everyone leaves the room. And one thing I've contemplated as a mediator is saying to clients afterwards, look, you can't reveal, what's happened. Like, go home, get on X or whatever it's called, Facebook, go down the pub, and even other publishing. I've put that in there because we shouldn't really have to remind people of it, but sometimes some solicitor firms might say, look, we had this mediation and this great thing happened, and they reveal circumstances which are going to betray the actual case. So I just remind people of that is a breach of the confidentiality agreement that you've signed with the parties. And obviously the mediation agreement confidentiality terms can be enforced post ipso facto. So it's an important thing to remind ourselves of, because otherwise things can, as Ingmar says, they can fall over, or it leaves you in strife in terms of dealing with your opponent next time around.
So we're doing pretty well, Richard. We said we'd stop talking at 6:10, and it's 6:10 now, and we only have one slide left, and I think we've pretty much dealt with it. But anyway, what?
Consent. Look, this is something I mentioned before. Terms, just when you turn up, know what you want to do, and if it's something out of the ordinary, for goodness sake, tell the mediator, tell the other side, look, normally we do consent terms of judgment, but this time we want to do something else. Let people know, because sometimes, as Ingmar says, people negotiate on a certain understanding or assumption, and then the party then halfway through the day says, oh, hang on a minute, we need to do X, Y, or Z. And the copy's hard electronic. As Ingmar says, be working on it, or even better, have it available to you. I know most of the mediations that I'm involved with in whatever capacity is, someone will come up with terms electronically available which can be fiddled with and massaged if we get to the happy resolution of things.
Yeah, bring a laptop.
Bring a laptop.
Genuinely, I've had at least two where people have had to sort of phone and trying to dictate additional terms, and then it's, someone's somewhere else is typing them, and then they come back and there's a typo in it. Bring a laptop with you. So we deliberately, hopefully we haven't sped through this too quickly, but we deliberately wanted to stop a good 15 minutes or so early in the genuine hope that there would be not only questions but comments, because I suspect that most of you have been in mediations, and so we're hoping to generate at least some discussion, but questions alone. Now, those who are online, I'm told there is a facility for those questions. I presume, do they put them in as chats in the...
In a pop-up there.
In a pop... Okay, well, we can see them. Where will they see them? They'll see them as a...
You can look after that, Ingmar.
As a in the chat. Okay, in the chat. So, for those who are online, feel free. Richard's going to sit in front of the screen and monitor it, because, my glasses are pretty good, but they're not that good. But let's start with in the room. Colin. Colin is a member of our floor, by the way, and this Dorothy Dixer was not provided by either of us. Colin McGee.
So, Richard, you mentioned support persons at mediation. I've had a number of mediations where I've been appearing for a party, and it's been clear that
Come up. In all seriousness, it's only because the people online...
They can hear.
They can hear it? Oh, good. So you can stay sitting. As soon as you don't have a jacket on.
Just walk on them down here. Just want to see what you're wearing.
where the support person for my client has become the major impediment to the resolution of the matter, because they're either think that they're a bush lawyer or they've got some other interest themselves that creates a problem in resolving. In your experience, how do you solve that kind of issue if you can?
Well, I think...
I haven't had that issue.
Well, I think you can, and it reminds me of another point I wanted to make, which I'll come back to in a minute. But in that situation, presumably that person, the support person and the litigant, have a solicitor. If they have a solicitor, I think it's pretty easy to, or even better, counsel. You got two people instead of one to deal with the malefactor. You can put some pressure on that person and say, look, this is not on. If they maintain this approach, they're going to have to leave, whatever the case is. One of the things I always do at a mediation opening is to say, look, it's got to be your decision, because that's one of the things. Although it's, the court says you have to have mediation, and your involvement or your participation in it is voluntary, and it's got to be the litigant's decision. Otherwise, you get into all sorts of trouble. And if there's someone there sort of driving it, from the bush lawyer point of view, what I would do, and it has happened only a couple of times, you just say to the solicitor, look, that's not okay. If this person's going to continue to do this, they're going to have to remove themselves, or, they can sit behind the litigant, but, you have to be, I think from the solicitor's point of view, they have to be confident that the instructions they're getting are from their client anyway. So from the mediator, the mediator can't really, the mediator's not going to make any orders about who can talk to who and whatever. But, you can say to the solicitor, look, you want to look after your own interests and make sure that you're actually getting instructions from your own client. And your own client's not going to say, blogs talked me into it, or blogs, I would have taken the offer, but, my support person wasn't going to let me. And that does happen sometimes. It does happen. Now, obviously the other party won't know that because they're not in the same room, presumably. But I think that's the way to deal with it. Hopefully, if there's a legal representative there, you can go to them and say, look, you need to protect yourself. As Paul Keating said, always back self-interest. It's always got a good chance of winning. And you appeal to the solicitor from that point of view. The other point I was going to make about confidentiality is people being remote and things like that, which I failed to mention before, was that it's really important when you sign everyone up for a confidentiality agreement. I had something a couple of weeks ago. There was people in 5 different places. There was a claims officer here, there was one litigant somewhere else, someone else had COVID. Just get them all signed up. You can do it. Doesn't matter if they're signed up on different documents, as long as you've got complementary confidentiality agreements. It's fundamental, and then make the extra care. As the representative, you've got to sort of say, look, make sure you can abide with these sorts of rules. That's more from the mediator's point of view, I suppose, but it also affects the party.
It's a difficult one. I
It
mean,
is.
it's always a difficult one because a support person might think their role is to assist the person not to make a bad decision. And so it's really a matter of doing your best if you are acting for that party and you think the support person is actually getting in the way of trying to take the opportunity as politely as possible to make that point. I don't think there's nothing you can really do other than try to do your best to make that point to them both. Who else is in the room? Is there anything come up on the screen, by the way?
You have a question? I don't know.
No, you look at the screen while we take the question.
Okay, so on the defendant side of things, in the case of a court-ordered mediation, from time to time it happens that you get instructions well in advance that no monetary offers will be made. So in addition to writing to the other side, putting them on notice of that, saying you're still going to attend because it's court-ordered, and also telling the mediator, so they know what they're getting into, are there any other steps you would recommend that legal representatives take from it practically, ethically, or otherwise to assist the process?
Well, look, the first thing is, I mean, if those are your instructions, that's fine. I mean, that's your client's position. Find out what their interests are and remind them of those, okay? Because sometimes, as I said, they don't always align. They might say, look, on the case pleaded, on the defence, we're going to win, but they might have some other interest that they should worry about, that you should bring to their attention. For example, there might be something that the plaintiff, if you're acting for the defendant, hasn't pleaded, but you can see there, as plain as the nose on your face, it's a potential problem, or there's an exposure there. So in terms of preparation with your client, that's the sort of preparing your client thing. In terms of preparing the other side, you obviously communicate with them, you're open and frank about it, and that's essential. That's the starting position. The worst thing you can do is say, oh yeah, we'll see you there, and then they have no notice of you just not making any offers. Of course, not making any offers is still a compromise. If you're prepared to bear your own costs, it's still a compromise. It's difficult if your instructions are firm, make no offers. Well, you might be stuck with that, and that's happened to me in mediations. You made no offers, and you've but there's always a benefit in that. You might hear from the plaintiff, him or herself. You get an impression. You can report back. You get the position paper. You'll see what the issues are. It might not have been contemplated. Something happens at the mediation. If you do all the right things in terms of being open, being patient, all that sort of stuff, something good might come of it. But look, if your instructions are make no offers, I mean, you're a bit limited as to what you can do.
Yeah, other than, as you say, prepare the other side for that.
Yeah.
And at least have your client turn their mind to, is there anything they can offer that's not monetary? May not be. Acknowledgement, each party pay their own costs. And of course you'd say to your client, unless the plaintiff is seriously asset rich, that they may still end up wearing costs at the end of the day. So do they really want to not offer anything at all if they could make this go away for something a lot less than it's going to cost them to run it and win it? But if that's still their instructions, yes, it's all about preparing the other side and being clear with the mediator. It's about being clear. So, because as I said, the couple of mediations that I've had that have gone seriously off the rails is where one party has considered the other one to have misled them. And in circumstances where the actual amounts being offered are actually sensible, but they are walking out because they were negotiating on a certain basis and the other side said, by the way, we also want X, and they've never mentioned that before, and it's like, oh, well, you're not serious, and we're walking out. Well, in fact, X wasn't actually that bad. If it had been put in the beginning, it'd probably still be in the room. So open communication, important. Anything on the screen yet?
Well, not so I can.
Our 130 people who are
I don't think so. But
who are actually currently cooking dinner, looking after their kids while the CPD is playing in the background. None of them have chatted yet.
well, I don't pretend that if there is something there, I'll be able to find it.
Okay, well, let's come back to the room then. We've actually got a lot of people here in the room too, which is great. Come on, wants to come back in. Come in.
Just trying to rehash all my life. From an ethical perspective, where you don't have a court-ordered mediation, where the parties have agreed to mediate, and where the defendant has no intention of making an offer but appears to have agreed to a mediation for an ulterior motive of apparently bleeding.
This really is your life.
My life. So I've had that situation where the defendant was a big corporate, agreed to a mediation. We paid a very large amount of money to have a former High Court judge mediate the matter. And the defendant turned up and said, we will make no offers, and that is the only offer we will make at the mediation.
Yeah.
Without putting anybody on notice. And essentially that was a very short mediation where my client ended up wearing half of the mediation costs, which was a considerable amount of money for an individual that then essentially clearly the position was to take away their right to run a matter.
I mean, you're right, it could have been some sort of tactical play, but it does sound to me like there was a fundamental failure of pre-mediation communication. And you say deliberately so, and maybe so, but if so, that should come under the heading of ethics, I think.
Yeah, that's what I said. I said from an ethics perspective.
Yeah.
Look,
They might say, well, look, our position is we will pay out to date very substantial costs and disbursements, and that in itself is a compromise of our position, which is we get a verdict for the defendant and you pay all of that, which is what the court accepts as being a compromise. But in terms of, as Ingmar said, trying to avoid that situation, I mean, it's very difficult to prove they did it for a proper purpose, but in terms of trying to avoid that situation, I mean, you would hope that the very expensive mediator would have, prior to that situation, got the parties into a exchange of communication, if not with each other, at least with him or her, about what their bona fides were, what was going to happen to try and avoid that situation. So, look, I'm very disappointed to hear that, and I won't ask what happened in the end, but look, it's very hard to say that was done for an improper purpose. Maybe from your jaundiced point of view, that was what it looked like.
All right, as long as you got paid, Colin, for being there. Any other comments, questions? Observations? Experiences? Colin's been sharing some of his experiences. Anyone else want to share?
Still can't detect anything here, Ingmar.
Still can't.
No, but so I send an apology if anyone's writing in. Can't see anything.
Right.
Obviously explained everything beautifully.
Yes.
Right,
yes.
Well,
I think we've reached a natural conclusion, have we not?
We have.
So thank you to all of you who've made the effort to come here in person. No disrespect to those online, and we do welcome them and love them, of course, but it is particularly nice to see people in person. So it's great so many of you were able to do that today. There are some drinks and nibbles for those who have an interest and capacity to stick around for little whiles, and we certainly welcome you doing so, and we're happy to answer any questions or chat informally about anything that you weren't brave enough to raise in front of everyone. So feel free to stay and join us for the next half hour or so. Thank you very much.
Thank you.